India, revisiting the definition of workman. Introduction. While various concepts under Indian employment law have achieved some sort of streamlining over the years, one question which has failed to disappear and keeps resurfacing before employment lawyers, both on the advisory and the dispute side is, who is a workman? First principle. Going through the definition of workman under the Industrial Disputes Act, 1947 would reveal that there is a two-step process to establish if an employee can be categorized as a workman. The first step, included persons, is to identify whether the employee is employed in an industry to do any manual, unskilled, skilled, technical, operational, clerical or supervisory work for hire or reward, whether the terms of his employment are expressed or implied. Second principle. The second step, excluded persons, is to identify whether the said employee 1. is subject to the Air Force Act, or the Army Act, 1950 or the Navy Act, 1957, or 2. is employed in the police service or as an officer or other employee of a prison, or 3. is employed mainly in a managerial or administrative capacity, or 4. is employed in a supervisory capacity and draws wages exceeding INR 1,000 per month, or exercises functions mainly of a managerial nature. An employee who is employed to do any of the type of work enumerated in the first step, and can also be excluded from all the categories in the second step, can be called a workman. Revisiting the definition of workman in the light of recent court judgments. 1. In Sharad Kumar vs NCT of Delhi, it was observed that the determination of the question of an employee being a workman or not depends on the types of duties assigned to or discharged by him and not merely on the designation of the post held by him. Neither the state government nor the High Court made any attempt to go into the different types of duties discharged by the respondent with a view to ascertain whether he came within the meaning of workman under Section 2 of the ID Act. Hence, the matter was referred to the Industrial Tribunal, Labour Court for adjudication. 2. In R.G. Makwana vs Gujarat State Road Transport Corporation, it was held that any person who has been dismissed, discharged or retrenched in connection with or as a consequence of a dispute is also included within the definition of the workman under Section 2. What is important and relevant is the date of reference, as on that date requisite conditions of the definition of the term workman as per Section 2 have to be satisfied. In this case, the workman was a dismissed workman and his salary on the date of reference was clearly covered by the main definition of the term workman and did not fall within the accepted category of Clause 4. 3. In Bombay Dyeing and Manufacturing Company Limited vs R.A. Bidu, it was held that the person is said to be employed in a technical capacity if he possesses some special skills. The court considered the nature of his work and held that the work done by him was not of a technical nature as it did not require application of any special knowledge which would result in the creation of a work peculiar to the talent of the respondent. Hence, the petition was dismissed. 4. In Arpal Govindraj Rao vs C. Bogaigi of India Limited, it was observed that where an employee has multifarious duties and a question is raised whether he is a workman or some other than a workman, the court must find out what are the primary and basic duties of the person concerned, and if he is incidentally asked to do some other work, which may not be necessarily in tune with basic duties, these additional duties cannot change the character and status of the person concerned. 5. In Ved Prakash Gupta vs Telton Cable India Private Limited, it was held that the person employed in managerial capacity or administrative capacity is not a workman. A single uniform definition for workman is the need of the hour, considering all the confusion of the courts on the subject as to who is workman and who is not, under the various legislations. While determining an employee is workman or not, we have to assess the dominant nature of work, disciplinary powers, employer-employee relationship, supervision, power to assign leaves and other important things discussed above, and it also varies from situation to situation. Any questions? Ask C-Quel.